Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Nick Esterbauer.
Hi, I'm Zahra Attir.
Welcome to Hull on Estates. Today you're listening to episode number 680, and we will be discussing guardianship bonds. How are you doing, Zahra?
I'm doing well. How are you?
I'm doing okay, thanks. Trying to stay warm. It's possible our viewers may see some flurries out the window today. It's winter is coming and holiday season approaching, so it's always an exciting and busy time of the year.
It is, and with the hour change, we have shorter days as well. So, but the holidays are coming up, so that's exciting.
Yeah, so Zahra, our first podcast together, we spoke about estate administration bonds, and it was such an interesting discussion. I thought, hey, let's do a follow-up. Let's talk about guardianship bonds this time. So if anyone wants to listen to our previous podcast on estate administration bonds, we will include a link to that in the blurb for this edition. That's episode number 675. And before we begin, just want to pause again like we did last time. And I mean, bond is a word that we throw around an awful lot. Not everyone knows or thinks about what it actually means. So I, again, took a look at Black's Law Dictionary, and it has a definition included for fiduciary bond. And that's a type of surety bond required of a trustee, administrator, executor, guardian, conservator, or other fiduciary to ensure the proper performance of their duties. So that's really the key. It's something that may be required by the court and may be recommended by the public guardian and trustee in the context of an application to appoint a guardian of property. And today we are talking about applications to appoint guardians of property under the Substitute Decisions Act. So guardianship appointments in terms of adults who are incapable of managing their own property and they need someone to assist them in making decisions and administering their affairs on their behalf. And the focus is, of course, ensuring the proper performance of duties. It's sort of like an insurance policy to satisfy any concerns that the court or the PGT might have relating to risk in permitting someone to administer someone else's property, whether it's of meaningful value, whether that person is perhaps a non-resident or some other reason. And Zahra, you found on the PGT a definition of a bond that's maybe even more specific to what we're talking about today.
Yeah, so the PGT has a guide that's called Becoming a Guardian of Property. And in that guide, they've defined a surety bond as a special form of insurance that protects the incapable person's money in case of theft or fraud. So it's a narrower definition in the context of guardianship applications, where they're saying that the idea behind posting a bond is to protect the incapable person from the guardian committing fraud or theft.
Right. And Zahra, we've gone through the Substitute Decisions Act, which provides us with guidance on when a bond may or may not be required. Do you mind highlighting the main reasons when a guardianship bond is required?
And so usually the bond is required if an applicant to a guardianship application is a non-resident of Ontario. And we've also found that usually the PGT recommends that the court require a bond if the assets of the allegedly incapable person are more than $100,000.
Right. So maybe we'll just take a step back and look at the most common scenarios where we see applications to appoint a guardianship property, because it might give us some ideas on just how common these issues are, the bond issues, and when we need to address them. So I think the top few scenarios I see are where there's an aging relative, they're beginning to suffer from dementia, and then they require assistance typically from younger family members in administering their property. We'll see applications for guardianships of property in those scenarios. In the personal injury world, we'll often see someone who's injured, and as a result of their injury, they're entitled to compensation, but they also are no longer capable of managing their own property. So we'll often see an application in that scenario. And another one I think I'm seeing at least with increasing frequency is where there's a child who reaches the age of adulthood, but is still not capable of managing their own property. Often it's someone who has autism and other diagnoses as well, but often a combination of factors. And so in that scenario, you're often having either an older family member, a parent, parents, or siblings on to be guardians of property. So in two of those three scenarios, at least, you see people with meaningful property, likely exceeding the $100,000 that Zahra just mentioned, and likely going to have to address the bond issue.
That's right. And should we talk about some scenarios where a bond may not be required or it may be required, but we can request for the court to dispense with that requirement?
Absolutely.
Right. So Section 24, Sub 4 of the Substitute Decision Act does give the court discretion to dispense with the requirement of a bond or reduce the amount of the bond that is required. So even if, in certain scenarios, even if the PGT recommends that a bond be posted, the court has discretion to not follow that recommendation. But usually the court takes the PGT's opinion into consideration and it puts weight on that recommendation. So I can talk about a case where it was a scenario where the court decided that a bond wasn't required, and though the assets of the incapable person far exceeded the $100,000 amount. So this is a case called Connolly and PGT. It's a case before the Ontario Superior Court, and it's from 2019. So in this case, the applicant was the mother of the incapable person who was an adult, 23 years old, and he was injured in a car accident when he was 8. And his assets were more than $2 million, and this was due to settlements that were reached with respect to the personal injury claim. And the court found that the requirement to post a bond should be dispensed with, even though his assets were quite significant. And the reasoning the court gave is that there are sufficient checks and balances in place to make sure that his assets are protected. So one of those checks and balances was that, according to the management plan, the applicant planned to manage the assets in a conservatively managed portfolio with BMO. So the court found that she couldn't access large sums of money immediately. And the court also held that she would need to pass accounts, and that this matter would be reconsidered every time that she passes accounts. And it also took into consideration the costs of posting a bond. So in this instance, it would have been around the premiums that would have been paid every year would be around $8,000. That's quite significant, and the court thought that would erode the capital, the investments, and the assets of the incapable person.
Right. So that case really raises a couple of really interesting points, really important points. The idea of those checks and balances. I mean, really, it goes back to the whole purpose of a bond, ensuring that the fiduciary is going to act in accordance with their duties. Another form of a check and balance, of course, is the appointment of a co-guardian. So we've seen applications where the appointment of a non-resident and a resident of Ontario is requested together, and the court has been satisfied that there's sufficient security there without the need for a bond.
That's right. And I've also found that if the court is sufficiently satisfied that the applicants that are acting in the incapable person's best interest, or that they're posting a bond could cause undue hardship or financial hardship, in that case, in those cases, the court is more amenable to dispensing with the bond.
Right. So I think it's important in situations like this where we're routine to help a client with the appointment of one or more property guardians that were considering the issue of a bond, will this applicant or will the person whose appointment they're seeking qualify for a bond? Will they be able to pay it? Is there money to pay it available at the outset of the guardianship appointment? Because we don't want a person's affairs to be hanging in limbo while we're trying to address the bond issue. And in many circumstances, I mean, if the PGT is making one recommendation, you need to consider if the PGT is recommending a bond, does it make sense to try to get the bond dispensed with anyway? Probably not in most circumstances. I know we typically see the court side with the PGT, and the PGT's raised legitimate concerns, and we want those to be addressed as well. So just something to be considering on any new guardianship matters or on any guardianship matters where we're seeking a change in guardians. Can we address the bond issue? Because we don't want it holding up the whole thing.
Yeah, that's a great point.
So I think, Zahra, this concludes our podcast. Until next time, we want to thank you for listening. I'm Nick Esterbauer.
I'm Zahra Attir.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website. Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.